Understanding eminent domain in Oklahoma. Can the government take your business property? Few things disrupt an Oklahoma business, commercial development, or rental property like a government notice declaring intent to acquire your land. This process, known as eminent domain, kicks off a high-stakes legal proceeding. For business leaders across the state, knowing your constitutional rights during a condemnation action isn't just about protecting a piece of real estate, it is a critical defense of your operations, equity, and bottom line. Let's break down exactly what constitutes eminent domain under Oklahoma law and, most importantly, whether the government is legally required to pay you for it. What constitutes eminent domain? By definition, eminent domain is the sovereign power of federal, state, or local government entities to acquire private property for public necessity. Under Oklahoma statutory law, this power is uniquely delegated to specific private corporations operating in the public interest, including midstream pipeline companies, electric utilities, and railroads. This power, however, is heavily restricted. Before any taking can legally proceed, the condemning authority must strictly prove two core elements. Lawful authority. Not just any government office can take your land. The entity forcing the acquisition must have specific power written into Oklahoma law. This usually means state agencies like ODOT, local city governments, or approved utility companies. Legitimate public use. The government cannot take land for private use. The project must serve the general public, such as expanding an Oklahoma highway, installing municipal water lines, or building utility towers across a region. The economic development trap. How Oklahoma is different. A common point of confusion for business owners stems from the U.S. Supreme Court's landmark Kello decision, which held that under the federal Fifth Amendment, public use could include taking private property for private economic development. However, Oklahoma has explicitly repudiated this federal standard. The Oklahoma Supreme Court has interpreted the state constitution as providing far greater safeguards for commercial landowners. Under Oklahoma precedent, economic development alone does not constitute a valid public use. The state cannot condemn your property for the financial benefit of another private entity unless the property meets strict, statutory definitions of structural blight. If your property is taken, does the government have to pay for it? The right to payment. Oklahoma's pay before you take rule. Both the Fifth Amendment of the U.S. Constitution and Article 2, Section 24 of the Oklahoma Constitution firmly protect property owners. The government cannot take or damage your private property for public use without paying you just compensation. Crucially, Oklahoma enforces a strict pay before you take rule. A government agency or utility company cannot legally seize control of your land, block your access, or break ground on construction until they have either paid you an agreed-upon settlement or deposited the court-appraised value directly into a secure court fund for your benefit. What counts as just compensation for businesses? In Oklahoma, just compensation is defined as the fair market value of the property on the exact date it is legally taken. However, for commercial landowners and business operations, a condemnation action is rarely a simple, clean real estate transaction. To fully protect your investment, just compensation must frequently account for total takings. If the state takes your entire business location, you are owed the full market value of the property from corner to corner. The catch? Government appraisers frequently miss the true value of specialized commercial upgrades. A fair payout must cover the land, the buildings, and every permanent improvement you've invested in, from your security fencing and private drainage systems to your customer parking lots and signage. Partial takings and damages to the remainder. If the Oklahoma Department of Transportation, ODOT, only takes a 15-foot strip of your front lot to widen a highway, they must pay you for that specific slice of land. Crucially, they must also compensate you for the loss in value to the land you are left with. For a commercial property, losing that small strip could destroy your front parking lot, block customer visibility, or ruin semi-truck delivery access. Oklahoma law explicitly mandates that the government pay for these consequential damages to your remaining business operations. Inverse condemnation. When the government takes land without asking. Sometimes, a government agency doesn't formally file a lawsuit to condemn your property, but their physical actions or infrastructure projects completely destroy its utility. Classic examples include a city project that causes permanent flooding on your land, or a road design that entirely blocks customer access to your storefront. When this happens, Oklahoma law allows business owners to go on the offensive. You can file an inverse condemnation lawsuit. This essentially flips the script, allowing you to drag the government into court and force them to pay for what amounts to a de facto, unofficial, taking of your business property. How the eminent domain process works in Oklahoma. If an Oklahoma state agency, municipality, or utility company targets your commercial property for a public infrastructure project, you are thrown into a highly structured legal timeline. Navigating an Oklahoma condemnation action generally follows this step-by-step path. 1. The initial offer. Don't take the bait. The very first sign of an eminent domain action is usually a knock on the door or a certified letter containing an initial written offer and a copy of the Oklahoma landowner's Bill of Rights. While the government is legally required to hand you this document to prove they are negotiating in good faith, remember that their opening offer is rarely their best offer. In Oklahoma, a bona fide negotiation means you have the absolute right to see the exact appraisal report they are using to price your land, giving your legal team the perfect baseline to poke holes in their math and demand a higher payout. 2. The commissioner's phase, the first real valuation battle. When talks stall, the government takes the fight to court by filing a condemnation lawsuit. But before a regular judge or jury ever looks at your case, Oklahoma uses a unique mid-step. The judge appoints 3 local property owners, called commissioners, to act as neutral third-party evaluators. After a formal 10-day notice, these commissioners will physically walk your property to calculate what they think you are owed. Do not treat this phase lightly. The moment they file their written report with the court clerk, the countdown begins. You have tight statutory deadlines to object if their math falls short, making it vital to have an experienced attorney presenting your business's true financial damages to the commissioners from day one. 3. The jury trial, your ultimate backstop against underpayment. If the commissioners come back with a lowball number, you do not have to accept it. You have a constitutional right to take your case to a jury of your peers and let them decide what the government truly owes you. But you must act immediately. In Oklahoma, you have a strict 60-day window from the exact day the commissioners file their report to demand a jury trial. If you miss that statutory deadline by even a single day, you are legally locked into whatever number they wrote down. 4. Forcing a jury trial is how you level the playing field. It gives your legal team the power to put commercial appraisers, traffic engineers, and financial experts on the stand to look past the government's basic metrics and expose the real economic devastation done to your business. The Oklahoma fee shifting advantage. Oklahoma law provides a major incentive for landowners to fight an unfair offer. If your legal team takes the case to a jury and the jury awards you an amount that is at least 10% higher than the commissioner's initial recommendation, the court can order the government to pay your attorney's fees, appraisal fees, and engineering costs. The takeaway for Oklahoma business owners. When the state utilizes eminent domain, you may not always be able to stop the project from happening, but you can stop them from underpaying you. The government's initial offer is rarely their best offer, and initial appraisals frequently overlook the complex logistical and financial damages a business suffers when losing its real estate. If you receive an eminent domain notice in Oklahoma, do not sign away your rights or accept an initial settlement figure before consulting an experienced Oklahoma civil and business law property rights attorney to ensure you secure every dollar of just compensation you are legally owed. For a free and confidential consultation with a Tulsa business law attorney at Kania Law Office, call 918-743-2233.